On the day Jeffrey Stambovsky was supposed to buy a $650,000 house, his chair at the closing table stayed empty. He had toured the property, he had signed the contract. He had already placed $32,500 in the seller's hands. The roof had not collapsed. The basement had not flooded. Nothing had happened to the house. Stambovsky refused to close because he had learned it was haunted. The seller kept his deposit. And at first, that sounds fair. A contract does not disappear because a buyer hears a ghost story. But the deeper this case went, the harder it became to tell which side was trying to escape the truth. Helen Ackley had everything a seller was supposed to have: a willing buyer, an agreed price, a signed contract, and a deposit large enough to prove that the deal was real. Then the buyer wanted out, not because the house was unsafe, not because Ackley did not own it, not because anything promised in the contract was missing. He wanted out because people said ghosts lived there. From Ackley's position, this was not fraud. It was buyer's remorse. If a rumor could destroy a signed contract, then what did a signature mean? And Ackley had an even stronger answer. She said Stambovsky already knew. According to Ackley and Ellis Realty, the broker telephoned Stambovsky before closing and told him about the haunting claims. Stambovsky reportedly joked that they would have to call the Ghostbusters, and then the deal continued. But Stambovsky said the call never happened. If that telephone call happened, the case was almost over. He had been warned. He had understood. He had signed anyway. Then as closing approached, he changed his mind and tried to turn the ghosts into an exit. One call could decide whether this was disclosure or surprise. Stambovsky's version was completely different. He came from New York City. The house stood in Nyack, where its reputation had circulated for years. He was not part of that local memory. He had not grown up hearing the stories. He said he saw a waterfront Victorian, not a famous haunted house, and he said the reputation reached him only after his money was committed. If Ackley's telephone call happened, he was a buyer trying to escape a bargain. If it did not, he had discovered the most unusual part of the property only after leaving became expensive. One conversation, two incompatible stories. The stories were specific: footsteps moving through empty rooms, objects appearing without explanation, beds shaking in the morning as though something unseen wanted the children awake. For people in Nyack, the house was already a local legend. That mattered even if Stambovsky did not believe a word of it, because one day he might need to sell, and other buyers could believe. Other buyers could hesitate. Other buyers could attach a price to the story. The question was no longer whether the house contained ghosts. The question was whether its reputation came with the property. Ackley had not sold him a broken building. The walls stood. The utilities worked. The Hudson remained outside the windows. Stambovsky had toured the rooms. He could have spoken to neighbors. He could have researched the address. And this was hardly a secret buried inside a locked government file. The stories had appeared in public. So why should Ackley lose a completed sale because an outsider failed to learn what people in town already knew? A buyer cannot investigate nothing, sign everything, and then demand protection from his own surprise. The trial court dismissed the action. Ackley had won the first round. Then the source of the ghost story came into focus. Not the neighbors, not an anonymous rumor, not a reporter inventing a Halloween headline. Helen Ackley herself. She had repeatedly described the alleged hauntings to the public. She had told the stories to a local newspaper. She had written about them for Reader's Digest. Ackley had given the spirits habits, personalities, stories of their own. For years, she had helped transform an ordinary address into one of Nyack's best-known legends. The public believed the house was haunted because its owner had asked them to believe. While Ackley lived there, the legend brought attention. It made the house unusual, memorable, worth talking about. But selling it changed the value of that attention. What had once made the property fascinating could make it harder to sell again. Stambovsky argued that no ordinary inspection could expose that risk. An engineer could discover a cracked foundation. A survey could discover a boundary dispute. But no instrument could measure what an entire town remembered about an address. You can inspect a wall. You cannot inspect a reputation. And Ackley had created that reputation herself. That sounds devastating for the seller, but it did not prove she had concealed anything. Ackley's answer was precise. She said she refused to sign her side of the agreement until after the haunting had been disclosed to the buyers. Her broker supported her account. The call had happened, they said. The Ghostbusters joke had happened. Stambovsky had known exactly what people believed about the house and proceeded. Anyway, if they were telling the truth, Ackley was not a seller caught hiding her legend. She was a seller who had disclosed it and was now being punished because the buyer regretted accepting it. Now, either the seller had hidden the truth or the buyer was weaponizing a story he already knew. The appellate judges were not conducting a trial about ghosts. They were not yet deciding which person had lied about the telephone call. The earlier court had dismissed the case before that conflict was tested. So the question was narrower. If Stambovsky's version was true, did the law give him any possible way out? Could an ordinary inspection have revealed the reputation? And could Ackley ask a court to ignore a reputation she had spent years making public? The judges were not deciding whether the buyer had already proven his story. They were deciding whether he deserved the chance to prove it. Start with Ackley. A contract has to mean something. The buyer saw the property and agreed to the price. The reputation did not prevent anyone from living in the house. The stories were public. Ackley said she had insisted on disclosure. Her broker said disclosure was made, and the alleged Ghostbusters joke suggested that Stambovsky understood perfectly well. If a buyer can sign a contract, wait, and later escape because a property has an unusual story, then every seller carries a risk no written agreement can control. Stambovsky argued he had not simply changed his mind. He said he learned the relevant reputation only after the deal was underway. Now take Stambovsky's version seriously. He came from outside the community. Nothing inside the house revealed its reputation. The seller knew exactly how famous the story had become because she had made it famous. She knew the information might matter to a buyer, and the deposit gave her leverage the moment he discovered it. If the telephone call never happened, Stambovsky was not asking the court to protect him from ghosts. He was asking for protection from a transaction whose strangest feature had been withheld until leaving became expensive. Stambovsky argued he had not simply changed his mind. He said he learned the relevant reputation only after the deal was underway. Pause here at the judge's bench. The appellate judges divided over a narrower question. If Stambovsky's version was true, could equity give him a path out of the contract? Some saw buyer's remorse after a lawful bargain. Others saw a seller's own public legend becoming a disclosure problem. The court was not choosing who had lied. It was deciding whether the case could go forward. If the broker's warning was enough, Ackley had the stronger bargain. If no warning came in time, enforcing the contract could reward a risk no inspection could uncover. If the seller created the haunting's public reputation, could she still use silence to keep the sale alive? Give me your ruling in the comments. Here's what the court actually found. The judges did not rule that ghosts exist. For this case, they treated the haunted reputation as something Ackley could not deny. Ackley had repeatedly presented the haunting as real to the public. For the limited purpose of Stambovsky's request to escape the contract, the majority would not allow her to deny the reputation she had helped create. The court wrote that, as a matter of law, the house was haunted. Stambovsky's claim to unwind the sale was restored, but his claim for fraud damages and his claims against the broker remained dismissed. The buyer received a possible way out. The seller was not declared a fraud. The court did not prove a haunting. It decided who had to carry the legal consequences of the story. Return to the closing table. The documents are ready. $32,500 is at risk. The seller sees a buyer refusing to honor his signature. The buyer sees a seller asking him to purchase more than the contract describes. Between them sits an empty chair and one disputed telephone call. The ruling did not simply choose the frightened buyer over the practical seller. It separated two questions. Could Stambovsky ask to escape the contract? Yes. Did the court award fraud damages? No. No court proved that a ghost had ever walked through the house, but Ackley had made the haunting part of its public identity. And once that story entered the market, the law could no longer pretend it existed nowhere at all. If the house was never proven haunted, but the story was, what exactly was being sold? Next time, a millionaire's will turns childbirth into a race for his fortune. A dead man, a city full of competing families, and one of the strangest inheritance battles ever brought before a court. Next file, the Great Stork Derby.